I'm the Deputy Legal Director for Voting Rights at the Southern Poverty Law Center. I'm very happy to welcome you all again to this panel focused on redistricting and voting rights. And to introduce our speakers, first we'll have Sean Young. Sean is the legal director of the ACLU of Georgia and manages a team of lawyers and volunteers on a variety of issues, but in particular has a long history in terms of protecting the right to vote. And some of his cases have included in Georgia the protection of over 160,000 voters who were subject to illegal purging, even though they were active voters who had participated in preceding elections. He's also pushed back on the state of Georgia's efforts to close polling places, unsurprisingly, in majority communities of color, as well as his work with respect to the First Amendment and making sure that citizens have access to the Georgia State Capitol to push on some of these policies, and also supporting reproductive rights for women. So he is also the former staff attorney with the ACLU's National Voting Rights Project in New York. He's clerked on both the 7th Circuit and the 7th District of New York, and is a former private practice attorney with the firm Skadden Arps, also in New York City. And then next, right next to me, we've got James Heaton. James is a supervising attorney for the Mission United Veterans Pro Bono Project in Broward County in Florida, where he services income-eligible military veterans, active duty service members, reservists, and their families facing a variety of legal issues. He's also on the board of the Broward County Bar Association Young Lawyers Division. He sits on the ABA's Commission on Homelessness and Poverty, and he's also a project leader for the Florida Advocates Veterans Practice Section. And then, as I mentioned, our third speaker who is on his way is Chad Dunn. And Chad is a partner with the firm Brazel and Dunn, which is based in Houston, although Chad is now living here in Austin. He's widely recognized as a top litigator, trial attorney, and has won numerous awards and recognitions for his work, often successful on behalf of various plaintiffs. He's also serving a second job as the Director of Litigation for UCLA's Voting Rights Project, and he's also an expert on apportionment and redistricting. He was involved in a Texas statewide redistricting issue. He's worked on vote denial and vote dilution cases, and so he's going to talk to us a little bit more about that work as well. So without further ado, we'll go ahead and start with Sean and then continue on from there. Thank you.
Nancy, please let me know if this is not okay, but I was going to go through prison gerrymandering, the law on that, and if you wanted, I could also talk about a little bit about disfranchisement. Okay, so for prison gerrymandering, and I might go a little quick, and so feel free to think about questions that will be asked at some point. So the setting is this. What is prison gerrymandering? So imagine you have a district of 10,000 people, or city with 10,000 people, and there are 5 representatives, and they all come from single-member districts of 2,000 people each. But imagine in one of the districts, you have a prison with 1,800 incarcerated people, most, if not all of whom, cannot vote because of felony conviction status. So in other words, in 4 of the districts, you have about 2,000 voting eligible people. Let's just assume they're all voting eligible. And in the one district, you have 200 voting eligible people. Those 200 people have as much say in the city's affairs as the 2,000 people in each of the other districts. And so we have a one person, one vote problem. And the question is, does that violate the Equal Protection Clause? And I'm going to summarize cases that have weighed in on this. The other context I want to add is that this happens a lot in rural, predominantly white cities, where the incarcerated population is largely people of color, Black people. And so you have essentially a district that is using Black bodies to increase their political power for a minority of voters. And another tidbit I'll add is that in a lot of states, the residency of an incarcerated person is counted as where they lived before they were arrested, not the prison itself. So their legal residency is not even in that district. So there have only been a handful of cases brought in this case. Nancy led one case, I was part of another, Nancy won, and I lost. So let's start with the case that Nancy actually won. So we had a, and I'm not going to go into all of the facts, but the analogy I gave is basically emblematic of the case she worked on. And the district court judge held that that situation was an illegal prison gerrymander in violation of the Equal Protection Clause. And the three elements this judge set out are as follows. First, are there large numbers of ineligible voters in that relevant jurisdiction? Number two, is that large number in a small subset of districts, usually just one? And number three, do the ineligible voters have any kind of, quote, representative nexus with the representative in that district? Applying these three elements, and these were built on a couple, two Supreme Court cases decided a few decades past, which said it was unconstitutional to just flat out disenfranchise tens of thousands of people in a, quote, federal enclave in Maryland. And another case which said it was unconstitutional to discriminate against military voters in a redistricting scheme. And so the court built on those principles to lay out those three elements. Applying those elements to the case at bar, it said number one, prisons have large populations of ineligible voters. Number two, the prison is in one district, so it's not just a small subset, it's in that one. And number three, incarcerated people in that city do not have a representational nexus with the district number. What does that mean? That's an inquiry that looks into, is there a real relationship between the ineligible voters and the representative there? Commonly with prison situations, there is none. Often the prison, actually I don't know if any city runs a prison, maybe some places, but usually the prison is run by the state. The city council obviously has no say over, how the prison is run, how the inmates should be treated. That's all state policy. It's a state-run prison. And shockingly to no one, city council members do not routinely go into prisons to solicit the feedback and views of the inmates. And there are other factors that you look at. And moreover, the city's nexus to the prison is only incidental. So for example, city provides fire services and ambulance. So yes, sometimes they might go to the prison to help you, but there is just no nexus. This is in contrast to other ineligible populations, such as children or immigrants or permanent green card holders. Those folks that live in a district, they can't vote, but there's a representational nexus because the kids go to the school district. They have a vested interest in how the district is run. The immigrants obviously have a vested interest in how the district is run. But prisoners are completely isolated. And so the court found that this was a violation of the Equal Protection Clause. Then later, I was part of a team that brought a case in Rhode Island. And the district court essentially mirrored what the district court in Nancy's case said. So city of Cranston and Rhode Island, same deal. 5 districts, 1 prison, wildly disproportionate. It went up to the First Circuit, and the First Circuit ruled against us. The First Circuit's opinion is not long, but its reasoning was basically this. The Supreme Court decided in Evanwell, and I'll get to that in a second, quite recently, that states have latitude to decide to use total population as a base for redistricting. As in, you look at your people in districts, you count all of the heads, even if they're not voting eligible. Then you divide based on that. the Supreme Court reaffirmed that states are allowed to do that. So from that one case, the First Circuit extrapolated the notion that thus prison gerrymandering is okay because you're just counting bodies that are physically there, case closed. And also, if the other voters have a problem with it, they can go to their city council members and just vote to change the lines. This, of course, is our position. This was a misreading of Evanwell. Evanwell's holding was limited to saying, as a general matter, you can divide districts based on total population, as states have been doing from the beginning. But prisoners are, incarcerated people are a completely separate and isolated group of folks that, if you have a large number of them in a district, can dramatically shift the weight of the votes in that district. So that's kind of the summary. And do you want me to go on to felon disenfranchisement? Okay. Briefly, felon disenfranchisement is obviously a huge topic that can take up an entire conference. But what I'm just going to focus on is the notion of moral turpitude. In a lot of states, the constitutions will strip the right of vote away from those who have been convicted of a crime or felony, quote, involving moral turpitude. Sometimes they call it an infamous crime, and some states say those are roughly the same meaning. The question, of course, is what is a moral turpitude crime? And this is the question that plagues the nation, right? It's very confusing. No one really understands what it means. There was a lawsuit brought in Alabama to try to give clarity to that definition, and the legislature ended up passing a law clarifying what involves moral turpitude. The general standard is this like very arcane language, something to the effect of, is the crime contrary to justice, honesty, modesty, good morals, or violates man's duty to man? So like, good luck, that's standard. And at least a lot of courts, even the Georgia Supreme Court, has said, okay, we acknowledge that this is not like a clear test, right? And a lot of state courts have been reluctant to articulate something any clearer than that. A lot of the reasoning over the last century, states are just kind of like, I know it when I see it. Like, I mean, of course that's evil. So that's a crime. Of course drug distribution is evil, because aren't drugs bad? That involves moral turpitude. Like very conclusory kind of reasoning. But at least but around the country, we are able to extract some principles of how to define moral turpitude from various state court decisions. And my laying out these factors does not mean I endorse all of them, but they are some of these factors. So typically anything involving fraud, even if you're still writing a bad check for $50. Anything involving fraud, a falsehood, kind of like the rules, sort of, in witness impeachment cases, that involves moral turpitude. And they trace that to Roman times when they first created the concept, and that when they first created the concept of moral turpitude, it was originally designed to look at if someone is credible or not. And people who have lied are not worthy of credibility. So that's that ancient root. Some cases look at whether the crime is malum in se or malum prohibitum. I forgot what that meant. The last time I studied that was watching Legally Blonde. So I had to look up, like, what does that mean again? So malum in se is something that's, inherently morally evil. We all agree it's evil. Malum prohibitum is something that's wrong just because the legislature says it's wrong. So if the legislature says it is wrong, you'll be fined if you speed through a stop sign, that's malum prohibitum, not something evil in itself. But, you can already see the tension, right? Running through a stop sign could hurt someone, blah, blah. And so, like, a lot of courts just have to wrestle with that. Some courts say any crime where there's an element of repetition, not talking about prior convictions, but just an element of repetition. A lot of felonies are like, if you do this misdemeanor 3 times, then it's a felony. Some courts say that involves moral turpitude. Some courts, not a lot, look at social acceptance, which is probably a theory a lot of judges don't like, but look at evolving moral standards and see if it's bad or not. And another test is, does it harm third parties? So they really seized on the language of, does it violate man's duty to man? Thus, you look at whether it significantly harms third parties. And there's an interesting, I'll just go into this a little bit and then I'll stop, but there's an interesting kind of distinction because back in the Prohibition era, when it was illegal to distribute liquor, a lot of courts almost unanimously said unlawful liquor distribution does not involve moral turpitude. At the same time, a lot of courts say illegal drug distribution involves moral turpitude. So, figure that one out. I think, you know, it's because underlying that, the only way you can explain that is we think drugs are bad and liquor's not bad, right? And so that's a lot of tension that is worth exploring. But I'll just leave it at that.
Okay, yeah, thanks, Sean, because I think the point of it, for your presentation in particular, of showing how we have felon disfranchisement laws that say certain populations are ineligible to vote either because they've been convicted of a felony crime, period, or because they fall within this list of disqualifying offenses, with states like Alabama and Mississippi that also has kind of a narrow list of crimes, you know, that they have, that are not always exhaustive and that they feel that they can expand upon. So you have what many people have identified as a ghost population, and then you want to turn around and use that very population to artificially increase your numbers when it comes to redistricting. So it's almost like they want to have their cake and eat it too, and what our cases are trying to push back on is, number one, both methods are wrong, but you can't deny a population the right to vote and then turn around and use their bodies as if they are a voting population for purposes of redistricting. So in that instance, we're talking about prisoners, about inmates, or disenfranchised populations. But we also have folks who are not incarcerated or otherwise incapacitated, who are still being marginalized very much. And in particular, we're talking about the homeless population, which unfortunately a lot of folks don't think about at all, but yet are eligible to vote. But there's no proactive outreach made to this community. So James, can you talk to us a little bit about the work that you've been doing to really, number one, expose this problem, and what we as a population of attorneys can do to help solve it?
Can I just say one sentence? Felon disenfranchisement laws were passed right after the Civil War in order to disenfranchise Black people. That's it.
All right, for sure. And it's, as earlier was said, I'm from Broward County, which probably rings familiar to a lot of you people when it comes to voting, especially in this area. And Florida right now is going through a huge issue with reform for felon disenfranchising, where we had a very successful session last year where we had an amendment passed, and it got brought back to the legislation to be heard for some fine-tuning. And when it came out the other side, it looked a lot different than the amendment that actually passed. So we're dealing with it, or it's been a mess. But anyway, I digress. So I want to talk to you today about homelessness and how the fact of being homeless and aspects of being homeless impact access to the ballot and impact other aspects of voting. And I want to start with talking about the census and the transitory status of homeless folks or people experiencing homelessness and how it really counts in the census. So really, it doesn't, it's not a reach of logic to say that unstable housing equals difficulty in counting somebody. Like, it just makes sense if you think about it. And it's really just a little bit further than that when it comes to the complexity of homelessness. We have these general ideas of homelessness. Just driving here today, you see the groups of men and women on the street. You see the guy on the street corner with a sign. There was a guy with a rooster on his shoulder. There's that aspect of front-facing homelessness, especially in metropolitan areas where the weather is fairly decent. Then you also have folks living in shelters. You have the folks living in more rural areas, folks living in woods and abandoned buildings. So counting homeless people, it can be very difficult just because of the complexity of it. And that's really just talking about adults. When we start talking about youth, so youth experiencing homelessness, those could be kids living with friends. It could be kids living in shelters. It could be kids sustaining themselves that are living independently that would never identify as homeless. Now, one of the issues with the way the census comes into play is when a census worker traditionally is going door to door, and taking their account, if there are people living in that household that aren't part of that family unit that are residing there temporarily, they can be counted as part of the census and should be counted. But you know, for the most part, the person in the household might not be aware of that. The person living there probably doesn't consider themselves as part of that unit, most likely because they're not part of that family. Now, one of the again, going back to the unsheltered, 32%, according to the HUD in 2016 study, 32% of people experiencing homelessness are unsheltered, meaning they're living out on the streets. So if you're looking at a count of people that are homeless from the census, you're not getting a full accurate count. The numbers are coming from service providers. They're coming from people that are in the continuum of care. They're coming from the shelters themselves. And doing the point in time counts is not really an efficient way. And the census is trying to do a good job at that and creating a more creative or innovative ways of doing it. For the past couple censuses, they've been doing service-based enumeration. So service-based enumeration is when they go to the service providers and they say, all right, who are the homeless people that you've contacted? Who are the homeless people that you're in connection with that you can help us understand who they are in this community? Now, one of the big issues with that is you're not getting a good geographical count of where these people reside or where they're from or how they got there or what their tie is to that community. So you're missing some important data and they're getting thrown into a catch-all on the census that's, you know, it's giving you a data point, but it's not really useful data for the purpose of what the census is used for, which, you know, when it comes to homelessness, it's trying to bring federal dollars into your community to help combat these issues. So there's a lot of issues when it comes to homelessness and counting the census, and that's really just a brief overview because, as you mentioned, you can really have a whole conference just on each of these little subtopics that we're talking about. Another thing I want to talk about too is voting rights when it comes to homelessness. And again, this is going to be like the 50,000-foot view of voting rights when it comes to homelessness. And really, when it comes to both the factors of a transient population and a non-traditional address. So one thing I want to point out is it's really difficult, and there's not a lot of data, and really reliable data, about how many homeless people vote in an election. You know, I was doing some research before this to see if I can find something reliable, and I kept seeing numbers look like 10% of homeless people voted in 2016, and then I looked for the source, and I was like, because that's what we said it was. So there's no reliable data. However, there is some reliable data on points of income. So we're looking at folks between the ages of 25 and 44 earning less than $10,000 in a family unit. You're looking at about 45% of that population goes out and casts a vote. We're speaking of general elections. Now, when you scale that up to a population of 74,000 to 100,000 of family income, you're looking at of the same age population. You're looking at 75% of that population. Now, it must be something more than, you know, just the availability of money, that is an aspect of it, but there are that clearly alludes to, or clearly points that there are barriers that lower income and therefore, in many of these circumstances, homeless folks, people experiencing homelessness are facing when it comes to accessing the ballot. Now, when it comes to registering to vote, there are laws in place that make it more accessible than it's ever been to be able to vote since the early 2000s, really, when there was the reform with the Helping Americans Vote Act. I'll be able to speak one day. Sorry guys, I flew in this morning from Broward County and it was very tired. So really the idea of having to produce some sort of residency, some sort of documents that prove residency. It doesn't have to be an ID, but it has to be something that proves your residency in that community. Now, it becomes very difficult when it comes to the homeless population. You're allowed to say, well, yeah, I live on that street corner, or yeah, I live in this park, or I live in that abandoned building, but you're going to need a mailing address. You're going to need a place to receive your mail. That might be great if you're engaged in a shelter, if there's a church. The PO box isn't going to work. You're going to need a mailing address. And let's say, great, you're hooked up with a shelter or a church that allows you to use their mailing address. How often are you really going to go there to check that mail? It's not a reliable mailing resource. So what if you're getting an election notice sent to you telling you, oh, there's going to change your polling place? You don't know. You didn't hear about it until it's too late for you to make the arrangements to get there. And that's just assuming that voting is in the forefront of your mind. When you're homeless, imagine the stressors of being homeless, of trying to think of where you're going to sleep, the stressors of just the conditions of being unsheltered, or if you are sheltered, the stressors of living in a shelter. These are things you're going to be thinking about first before you even start considering about voting. About, okay, well, I'm gonna make an effort to go out and register and go vote. Maybe you're focusing so much on just living, you're prioritizing your life to survive, you don't even know who the candidates are, which seems kind of crazy not to know who the candidates are these days, right? But if you're living in your bubble, if you're living in your world trying to survive, you're not concerned necessarily about who is there and what they're going to do. You don't have the time, you don't have those resources to go ahead and do the research to make it a priority, or you may not. Now, the process as well to register can be very confusing about, okay, what documents do I need to gather? How do I gather those documents? Who's going to help me get those documents? I don't know where to go. I have to go down across town to City Hall to get a copy of my birth certificate, or if you serve in the military, how do I get a copy of my DD-214 to show, to at least show that I'm a U.S. citizen, or that I am who I say I am, or how do I get an ID, or what are the requirements of this state that I live in what would I need to prove to show at my place of polling in order to not be turned away or given a provisional ballot? And who knows if that's going to be counted? I don't know. There's a lot of confusion for homeless people, and there's very few resources out there to help navigate this system. A lot of the resources are put into the emergent needs, put into the priorities, but there's just not a lot put into what can be done upstream to help early on in the process of getting people experiencing homelessness engaged in the voting process. Now, just helping to obtain an ID, which is something I'm not going to lie, we do. We do it in our office. When we have folks coming in, we have a homeless veterans project in our unit, and every veteran that comes in that we talk to, we always ask, are you registered to vote? The majority of the time, no. Well, would you like to register to vote? What are the barriers that you're experiencing that you see to register for voting? Why aren't you engaged? And then we work with them to get those documents or help remove those barriers. The problem is we don't have the resources to follow up all the time and say, okay, well, we're 2 years out of the general election. What are your plans? Where are you living now? Do you know where your polling place is? Or we're 10 months out of the general election. Do you know where you're going to be voting? Do you plan on moving? General election is the time of year is it can be a little cold out in a lot of these places, so a lot of homeless people experiencing homelessness may come down to Florida to my neck of the woods and say, hey, I'm here to vote. And we go, well, we don't even know, you're not engaged in the system. We don't know who you are. We don't have any of the documents that we needed at the time or that I need today to get you engaged. So really, some of the things that we've been looking at and researching for solutions are really begin at the beginning. Start from the early steps on how can we get these folks engaged. Ask questions at intake. If you're a provider, if you're in the continuum of care, if you engage homeless people, people experiencing homelessness on a regular basis or ever, start early. Ask, hey, what are your reservations about voting, or have you ever voted before? Do you have any of these documents that you may need? Help educate them about the requirements of how to register to vote, and what documents or proof that they might need when they go to their place of polling on that day. And especially if you're living in a place that borders another state or borders another district, and there's polling requirements that if you switch to a different district within a certain amount of days before election day, that you have to show X, Y, or Z proof of residency of where you are now. But especially if you're bordering another state where you might just be crossing a couple blocks and now having availing yourself to a whole new set of laws and regulations in place for what you need to show to vote. And work with those providers in your community. Stop working in silos. Start working with these other service providers in your community. As legal service providers, we can do a whole lot. We're in connection with a whole lot of people that are in the continuum of care. We're also entrusted often with people that are not in the continuum of care. How can we engage them with these case management services, and how can we use those case managers to inform us to work together to engage more homeless people and the like to be more involved in voting. Use services like HMIS and social workers and case management, and help demystify the voting process early. Now, we're never going to know how to engage and connect with every homeless person. It's just impossible. But if when we do have those opportunities to engage people experiencing homelessness, if we can help incrementally demystify the process of voting registration and voting, then that can provide a world of difference in the aggregate. So just those little things are things that we're working on at home. And Broward County, we have a lot more voting problems than engaging homeless people at this time. But we're doing what we can back home. So I really implore you to do the same thing and work with the Commission on Homelessness and Poverty and work with the ABA to review policies, bring these policies back to your folks locally and at your state, and see what we can do to make the world 1% less worse.
Thank you, James. And welcome, Chad. We're glad you made it. But before we move to Chad's presentation, if I'm not incorrect, Sean, I believe you worked on a case involving the state of Georgia's refusal to recognize homeless shelters or other non-traditional residences on behalf of homeless individuals for purposes of registration. Is that right?
That's right. There's not a case. Okay. We're looking into it. Yes, but long story short, a set of residents at a temporary transitional housing unit, basically they have a policy that you can stay there for 7 days every 30 days, but a lot of people use it as their home base. The registrar just looked at the address and said, that's not a residence, that's not a real residence, it's a business, and then removed them. That was the reasoning. We have asked them to stop doing that, and they have refused. So I'll just leave it at that.
The battle fight continues. Well, I want to make sure, because I know, again, Sean is going to be leaving soon. Did anyone have any questions in particular about the cases that he made mention of, or the prison gerrymandering issue in particular? Yes, ma'am.
So my question isn't so much about the gerrymandering with respect to prisoners, but it is with regard to prisoners in the census. And so with every person that's counted, there's a certain amount of money that a state will receive. So how will prisoners benefit from being counted and the money that a state is going to receive? So can you comment on that, please?
That's a great one. The question was, how does the counting of incarcerated folks relate to the census, and do states get more resources if the incarcerated people are counted? Nancy should feel free to jump in and correct anything I'm about to say, but it's my general understanding the census has now started to actually designate whether certain populations are in an incarceration facility or not. At least they started to about a decade ago. I think that's still continuing, so that at least states and municipalities have the data they can use to say, you know what, we're not going to engage in prison gerrymandering, so we're not going to count those folks. That's one respect. The second question is a little more difficult. It's in terms of allocating resources, so I'll be brief because that's not been my specialty, but I don't think that the national government gives you more money if you have more incarcerated people in one place over another. That's up to states, but I'm going to stop right there because that's the extent of my knowledge.
Yeah, and we actually had invited someone from the Prison Policy Initiative who works particularly on that issue, but unfortunately she was unable to join us today. But yes, I mean, the census has decided not to, as a general policy, promote or encourage states to not count prisoners where they're incarcerated, or to at least advise them to count inmates where they're from, but has left it up to the localities to exercise their discretion as to whether or not they're going to count prisoners the way they traditionally have been counted. And we have been successful at the local level in terms of pushing some counties and cities not to do the right thing in terms of how they count them. The preference, of course, is to count those individuals in the communities where they're from, because those tend to be the communities that do need those federal and local dollars the most, but at the very least don't take advantage of their physical presence by increasing the amount of money that you receive. And so the idea is at the very least don't count them at all. But I think we'll go ahead and move on to Chad, who's going to take us back a little bit to the rights restoration, felon disenfranchisement topic, and also talk a little bit more broadly about redistricting.
Well, thank you for having me, and my apologies to the panel and to the crowd for being a bit late. I'd always heard that Delta actually stood for don't ever leave the airport. So anyhow, I'm primarily a trial lawyer, litigator, and a lot of the work that I do is voting rights related. I'm based here in Austin, and I also run a voting rights clinic at UCLA in Los Angeles, which is where I was trying to come here. Two cities with like some of the worst traffic in America, and I was trying to get through it quickly. So anyhow, I was asked to come here today and talk to you about some pending cases, and the first one, I'm one of a fabulous team, and would be remiss to not mention I'm not the lead of this team, but I am participating in a case in Florida at this point on Florida's effort to enfranchise felons. So there's just a short bit of history here. A group of citizens got together with some like-minded organizations, and through a petition process that Florida has that's very similar to what a lot of Western states have, they were able to force a change that enfranchised convicted felons, or should have enfranchised convicted felons in Florida. I think the data show there's about 1 million of those such people. And the political parties fight over whatever impact that may have ultimately, but there's no doubt that there was an overwhelming vote in favor of enfranchising these folks. And so the legislature was displeased with the voters' decision, and so it adopted an amendment to its law that says, okay, fine, we'll re-enfranchise people, but only if they pay all of the costs and fees that they've been assessed by the court as a result of their incarceration. So it wasn't just enough to complete the terms of your incarceration and then receive your right to vote back, but you also had to pay back these costs. There's a number of problems with that, not the least of which is it sure sounds like a poll tax to people like me. But it also, it's difficult and in some cases impossible, the evidence of trial showed, for these people to find out what they've been assessed and what the points and the interests are on them, what the additional fees that have been tacked on by the government. And so a lot of times, even if you had the ability to pay, you still couldn't get your right to vote back. And so that case is pending in the federal court in Tallahassee. There are a number of individual voters and civil rights organizations involved. And the court initially ruled in an as-applied challenge that certain voters who had come to the court and filed this lawsuit were entitled to an order allowing them to vote without having to pay back these fines and fees. That's on appeal to the 11th Circuit. It was argued a couple of weeks ago. We're waiting on the 11th Circuit to rule, and then in a few weeks, however that turns out, if it turns out in time, there's supposed to be a trial on a permanent injunction rather than a preliminary injunction. So ultimately, the courts will sort that out. I won't get too much into the legal details, but there's an on-point 11th Circuit decision that ought to make this an easy case. The district court has ruled that way. But of course, the 11th Circuit's makeup has adjusted over time, and so it's interesting to see if this earlier decision will be followed or if it will be distinguished in some way. Now, also talking about the felon disenfranchisement, I think the question we had on the census count for the imprisoned, I'd like to take a minute and talk about a unique case that happened here in Texas that I was involved in, involving Beaumont Independent School District. So the Beaumont Independent School District, for those of you who are not from Texas, Beaumont is between the Louisiana border and Houston on Interstate 10. It's a port city, and it's a medium-sized city. It has been the subject of civil rights litigation since the advent as such. It's close to Jasper, Texas, where James Byrd was grew up to death in the 1990s. And to say there's racial tension there is to under-describe the conditions. A group of white citizens ultimately became dissatisfied with the Beaumont Independent School District. It had elected a majority of African Americans to its board of governors, the school board. And so they initiated a petition process. And the petition process was designed to get rid of single-member districts there and go to either all at-large districts or a split between at-large and single-member districts. And without getting into too much of the weeds, the advantage there is because the elections are set on days with very low turnout, that if you had at-large elections, or at least a majority of the seats were elected at-large, then it substantially increased the chances that the white minority, both by student population and voting population, could be the majority or run the school district. And there have been a number of lawsuits, desegregation lawsuits in Beaumont. I think they weren't certified as properly desegregated until 1985. There was a lawsuit in the late 1980s that forced them to go to these single-member districts. And so there's a lot of machinations to it. I was ultimately hired by the school district. We had a case in Washington, D.C. where it was enjoined, this effort to sort of take over the school board. And then the U.S. Supreme Court handed down a decision called Shelby County versus Holder, which undermined a part of the Voting Rights Act. And so once that happened, all the activity or litigation related to the school district went to the state courts. We ultimately were even successful at a trial in the state courts, convincing them that this was violative of the federal constitution, which still applies or is supposed to in the state courts. And then ultimately the state took over the school district, withdrew all of the elected members, and installed a non-African American majority, which is the condition today. The reason I talk about this is, number one, it ought to be talked about all day, every day. But number two, one of the arguments that the white minority made is that the reason that districts were drawn in such a way to elect a majority of African Americans to the board, or African American preferred candidates, is because there were prison and jail facilities. And those prison and jail facilities happened to be located in the so-called white district, one of the two so-called white districts. And that district, ultimately, their argument was that instead of counting those prisoners where they were housed, they should be counted where they were either lived at the time of their arrest or where they committed their offense. Now, this is an argument we often make in litigation, is that, the reason I point out this event is because these things that we argue over in court don't always, turn out exactly how you expect them in any given situation. And so you just got to do what's right for the sake of doing what's right, in my view. So let me give you another alternative example. Here in Texas, a great large percentage of our prison system is located in Huntsville, Texas. And they're counted in Huntsville. And so when state representative districts, state senate districts, and congressional districts are drawn, those people are counted there. And so there's been a number of analysis to that if you redrew, or if you counted these individuals where they either lived at the time of their arrest or where they committed their offense, to the extent that's possible, then that you would have a district or more that's located in rural areas that would ultimately move to more urban areas, where oftentimes that's where a lot of these arrests occur, or where these residents live. Now, people disagree about that, but my point is that we ought to just ultimately figure out what is the fair process regardless of the outcome, empower individuals to be properly counted for the census and not gained. And the condition that we have, as Nancy mentions, is that we're leaving it up to these local jurisdictions. And unfortunately, some don't even look at the question. And then others look at it, and their opinion of how it ought to be done is based upon the political outcome it will have instead of the voting rights outcome. And so now I'm going to transition and talk about a different subject, which is the unhoused. I know you've heard a little bit about that today. And what a challenge that has both in counting individuals, registering individuals, and in redistricting. So one of our tasks at the UCLA Voting Rights Project is we focus on the western part of the country, and there are a number of jurisdictions, large and small, but hundreds, we're trying to quantify them now, of jurisdictions that have a large population in them that is not counted in a particular spot or particular place. So this is difficult for financial allocation issues, but it's also difficult for drawing redistricting maps. So I'll give an example around the Four Corners area where Colorado and Nevada and New Mexico and Arizona come together. There are a number of Native American reservations there. And often Native Americans, if they are registered at the reservation or some general spot on the reservation. And if they're at least counted that way, then they count for apportionment purposes, and they count for purposes of essentially drawing the district lines, whether it's a county or school district. But if you can't tell where they are precisely, then you can't allocate the districts in such a way that it might empower their voting strength, right? So what often happens is the reservation gets stuck within one big district. The local community, which is run by typically non-Native Americans, then brings in another group of what I'll just refer to as non-Native Americans into that same district, and then they outvote the reservation. So if we had more precise information on the actual physical location of these individuals, it would benefit greatly the equity in redistricting. There's another group of citizens that, by not being able to know exactly where they are, or at least under the residency where they call home or return home, and that is individuals who are of course unhoused and individuals who live on boats and other vessels, which is a significant issue in Florida, and it is here in Texas as well. There's a number of people who live on their boats, and oftentimes those people are counted at the marina office, or where, and the marina office may not be there on the water, it may be somewhere inland, whoever owns the marina. This is true also with RV and travel trailer locations. In Texas, there's a Fifth Circuit case that went up 12, 14 years ago. At the time, I think there were something like 85,000 RV owners who, the testimony was very rarely, if ever, went to Polk County, Texas. That's about 45 minutes to the northeast of Houston. It's a rural part, sort of north of Beaumont, Houston. And, but you could register your RV there, that could be your residence there. You wouldn't have to pay income tax. That was the advantage if you're a citizen of Texas. And then, in many cases, these people had never been to Texas. Well, when that business started and these people started to register to vote in Polk County, and Polk County is not a large population county, I don't recall the numbers right offhand, but these people ultimately ended up controlling the elections in a county that they never spent any time. The Fifth Circuit said, despite a challenge, that those people should have to register either where they're originally from, or they have to return in some regular interval to demonstrate that it's a residence. The Fifth Circuit said, no, we're going to take their word for it, and they're today registered there. I think the numbers have almost doubled. But we don't often, and the courts don't often apply the same rule, I'm afraid, to the unhoused and to individuals that live in vessels or other types of facilities. So I'll give you one example. I represented an individual in 2008, the lead up to that election. Hillary Clinton and Barack Obama, of course, were fighting bitterly for the nomination. That election mattered a great deal here in Texas. Texas ended up being significant in that race. And as a result of that process, several million voters were registered in Texas that had never participated before. Well, Obama, of course, won the nomination, and as the general election got close, there was a massive increase in registrations in Texas. And in Harris County, there were hundreds of thousands that were unexpected. And in the last few weeks leading up to that election, Harris County rejected 68,000 voting registration applications. These were people, many of whom were denied the right to vote. They showed up later, they registered on time, they were entitled to vote, and they were told they couldn't vote because they were rejected. We sued over that, we ultimately unraveled that and fixed it for the future, but one of the things that we discovered that Harris County was doing, and I've now since learned many other counties are doing, is they have a GIS department. And when you fill out your application, you're allowed to say, and the cases say, I'm under the third overpass 3 miles down Interstate 45. But what was actually happening is when the clerks would receive this, if they couldn't find you in their geographic information system that the county operated, and sometimes these things are, I call them the ENIAC, it's a computer that fills up a room like this, hasn't been updated in decades. That's the mapping system some of these counties are using. And if they can't find what you said in there, then you get denied. And you're often told invalid address. And so a lot of these folks, of course, give up. And so anyway, ultimately we were able to fix that, but in your communities, you might see this, you might hear about this from folks, and that's something they're entitled to be registered in whatever location they get, whether or not it's got an official postal location. But another thing Harris County was doing is if you registered at a commercial building, which oftentimes shelters are in office buildings or something that's zoned commercial or reported commercial in the system, they would deny and say that's not a residential address. A lot of communities do that. So I think that's something to keep a lookout for. And then the last thing I'll mention is, because part of our charge here was to sort of communicate what others can do. And I think there's several things you can do. The most important thing that lawyers can do is anytime they interact with a member of the community about voting, the message ought to be it's safe, it's fun, and it's easy. Okay? Because what happens in all these press articles about all the litigation that we're filing is to the average reader, I'm afraid sometimes they look at it and go, well, that sounds like a mess, or I might get arrested, or I might have to worry about answering immigration questions about me or my family, or it sounds to me like they're not going to count my vote anyway. That's what a lot of people take away, frankly, from when we talk about voting systems. There's no question voting systems have some issues. They're not, in my opinion, they're not near as bad as some people make them out to be. But voting systems can be improved. But what that sounds like when we talk about that to other people is, I got to go down there and stand in line. It sounds like, in places like Texas, they criminalize a great part of voting. It sounds like I might get in trouble at some point. And it isn't going to count anyway because the voting machines aren't any good. And we're right to focus on the issues, but by and large, it's safe, it's fun, it's a rewarding process, and it's easy. And the more we can get that message out, the better. Now, the second thing I think folks can do with a law license is in your local community, you are a powerful advocate. You don't have to file a lawsuit to make change. I know that, for those of you who might litigate, and, we're, at least in my practice, right, I do, regular litigation as well. You send letters, and I mean, how many times have you sent a demand letter that says, if you don't do what I want, A, B, and C, all this bad stuff's going to happen, and they call you up and say, I'm doing it right now. We started 5 minutes ago. That's not normally what happens. What normally is you get a letter back saying, well, you don't do this, we're going to do, X, Y, and Z. But I have found in the voting context that there are no question there's some bad people that are in charge of elections in some places. But a lot of times it's overworked people with fewer resources than they really should have, who are trying to do the best job they can. And they stub their toe here and there, and the reaction they get is you're disenfranchising and all these bad things are going to happen to you. And as somebody in your local community who is no doubt well respected, a softer approach, at least initially. I mean, if you ultimately confirm that this is all intentional, as it often is in Texas, then you don't have a choice. But if you determine that this is somebody who wants to make it right, offer to volunteer. What can I do to help you? How can I facilitate this? Or can I help liaison perhaps with some of these other lawyers on your behalf to give you the bandwidth to straighten out these issues? And then, of course, when people approach you about their community, if you're interested in doing litigation or being a part of these things, then get a hold of one of these organizations. Any of the ones that you work with, and there's others. It used to be the case, and this is the last thing I'll say, it used to be the case that the Department of Justice reviewed all types of submissions of voting changes because there was this provision under the law that said certain places, most of the old Confederacy and some other counties, around the country had to go get permission from the federal government when they wanted to change the law. And 99% of the time they got the permission they But there was a federal clearinghouse for all of these election changes. All this stuff got reported. You could go to the Department of Justice website and you could look up your community and you could see they're going to close this polling location. They're going to do this other thing here. So organizations can track things and they can sort of see what the big issues were and devote their resources to them. Well, when the Supreme Court undermined that, that clearinghouse also disappeared. And so the only way anybody knows about what's going on in your community, a lot of people think, well, it was in the local newspaper, but that doesn't mean it got to the sources or to the people who have the expertise, the time, the wherewithal to do something about it. So, you know, speak up. If you're interested in being involved, the organization you call will almost always say, great, help us with this. You know, serve as local counsel if that's what you want to do. Take the lead in some cases where there isn't the bandwidth otherwise, you know, at the national organization. There's plenty of places to chip in, but the biggest thing is if you see something, say something. That applies here just as it does at the airport. I had plenty to see today in the hours that I sat there. Anyhow, I appreciate being here, and I'm happy to answer any questions if there are.
Thank you, Chad. And I do want to get to questions. I just want to add in terms of the Florida rights restoration cases, the Southern Poverty Law Center is also one of the partner organizations, and we brought a lot of the similar wealth-based discrimination, poll tax claims, but we've also, especially given the anniversary of the 19th Amendment's passage, we brought a 19th Amendment claim, and we're trying to kind of really push forward a theory of intersectionality that Professor Tammany Crenshaw from Columbia and UCLA has put forward in terms of what happens in terms of the impact when you require individuals to pay financial obligations, especially with respect to low-income women of color who are already entering the criminal justice system at relatively higher rates statistically than men who enter the system at a much more financial disadvantage because of all of the pay wage gaps that we're experiencing still in how our economy operates, and then also in terms of exiting the criminal justice system and not being able to find either permanent full-time or even reliable part-time employment, and therefore are least likely to be able to satisfy these obligations. So there's not a lot of jurisprudence, as we know, following the passage of the 19th Amendment, but we're hoping that our case will be able to really focus not just on the kind of theoretical legal principles that should be applied, but really force the courts, even with their changing demographics on the bench, to focus more on the individuals who are being impacted. And then the other thing I want to highlight, and I appreciate Chad ending his presentation on a higher note, because this is an issue internally that we struggle with. If we talk too much about voter suppression, then it turns people off and then it leads to apathy. But if we pretend like everything is nice and going well, then we're actually somehow giving more evidence or support for the idea that there's not an issue still when it comes to access to the ballot in our country. And so this is a tension that I think that we are having to grapple with, but at the end of the day, it should be about encouraging people to participate, because not voting really is a vote for someone who does not have your interests at heart. So with that, I'd like to open it up for questions. I saw a gentleman. Yes, sir.
I have to confess, 20 years back when I was a prosecutor, I never thought of this, but Chad, you really raised an interesting point. What is the remedy if I'm an individual and I've been improperly denied my franchise, my right to vote? What is the remedy? What damages do I have? What individual compensation? I've never contemplated that before, but as you were talking, I kind of came to mind, what's the remedy for the individual who was denied?
So I have two responses to that. In the Texas voter ID case, we actually brought a damage claim. Without getting into too much of the history, the Texas voter ID was blocked, and the Supreme Court said that part of the Voting Rights Act didn't apply. And then it went into effect. We had to file a new lawsuit in Corpus Christi that was ultimately successful. But in the interim, it was in place, and thousands of people were rejected from voting, and several of them were our clients. And so we sued on their behalf, and we included a damage claim in addition to an injunction claim in the future. And we put on some evidence of the harm, the personal harm that was ultimately suffered. And ultimately, the decision was made, like I think it is in a lot of, and this has a rule, you tort lawyers know better than I am, but in order to recover mental health or mental anguish, you typically have to have a physical injury. And so ultimately that was the principle that it was decided that it was incompensable in the past because there wasn't a physical injury. I don't think that that's by any means the law, but I'm aware of no voting case where damages were assessed. So typically the remedy is a prospective injunction that says that this person's entitled to this relief. Now, interestingly, there's a brand new case out of the Fifth Circuit called Stringer that I'm now involved in on remand, but was not involved before. The Texas Civil Rights Project was the lead on. And in that case, the Fifth Circuit made the decision that individuals who had been denied registration, essentially, it's a little more complicated than that, but they were denied effective registration. And there's no question that occurred. But then when the lawsuit was filed, the state rushed in and resolved their registrations. And so the state then took the position that those claims were moot because, okay, fine, they weren't registered at this earlier election, but we fixed it. That has, to my knowledge, that's an argument that's never been successful before. They had argued that in the voter ID case, and it's a very dangerous, slippery slope because what it allows the government to do is anytime you go find plaintiffs that have been harmed, they'll immediately register just those plaintiffs. So in the case of the felon disenfranchisement in Florida, where you have 1 million of them, these aren't the easiest people to find in some cases. And you locate them and they want to participate in the lawsuit, and the state immediately registers them. So you're in this constant circle of finding new plaintiffs, and then the state registers those. But you're not doing anything about this 1 million, you're doing something about this small. So anyway, hopefully that will be reversed in a higher court if it comes time to it, if the other circuits won't agree. But now it looks like in order to get relief, you've got to be able to demonstrate that this is going to happen to you again. And so this is another way, what I'll call anti-voting rights sources are fighting back. They're trying to make it so that you can't even get an injunction. You can't get damages and you can't get an injunction. And then, as this decision Stringer says, you can't even get a declaratory judgment that what happened to them was wrong because they no longer have right claims to complain about it. So it's a real issue, it's a hard question, but the answer is at best you're going to get an injunction. At least that's my view.
Yeah, I'm not aware really of any cases in the voting rights context that have awarded damages through a court order. We have had some success in a case that I litigated in terms of getting damages through settlement. But then the issue became, what is a price tag on the right to vote? Some people will say, of course, it is priceless, and I believe that it's priceless. But at the same time, especially at the local government level, what hurts is having to write a check for an amount. So I think that is another issue that we have to grapple with when an injunction really is, at least through a court order, our only sustainable form of relief. Yes.
Good afternoon.
Good afternoon.
For those of you who don't know by now, you've been missing too many seminars. I'm Beverly McCreary Smith, pastor of the National Bar Association, and I'm licensed to practice justice. I'm a resident here. And I'm now trying to get my Gold Star ID, that little Gold Star on my driver's license, which says I'm a bona fide U.S. person, and I should be able to fly. I was really delighted, James, by your remarks because you talked about homelessness. And I read through the rules that you have to satisfy to try to be able to meet the test. Either get the ID, the Gold Star, or the driver's license, the Gold Star. And they try to deal with people who are living underneath the overpass at I-35 and such and such, or I-45 in Houston and the like. That's one thing. Curious though, if you start putting that piece in place, how then can you translate that data into census documents, which will make it possible for us to figure out who should be counted where for census purposes? That's one. The other question, I don't even want to deal with the remedies issue, because it was so long ago that I taught choice, that anything I had is disqualifying. But I will say that between the homelessness, the fact that we now have, at least under the Department of Public Safety in Texas, some attempt to identify where people are for the purposes of locating them, so they can get this bona fide government ID. I guess a person who is not going to be flying an airplane if he or she really is homeless, but you never know. I think times could change it. So I'm concerned about that. The other thing that concerns me has to do with census data. It seems to me that the whole point of calculating people on a decennial basis is to figure out how much of our federal resources should be allocated across various political subdivisions in order to meet certain governmental needs and imperatives. So we will no longer have any unfunded, what they call the federal mandates or state mandates. So 2 things. I hope you folks work out your brilliance and synthesize it, because I think it's fascinating to listen to that. I almost want to write Lord, but I'm already retired.
Thank you.
It's interesting too with the real ID issue that you're talking about, that the little gold star in the corner, well, at least in Florida, it's in the top right-hand corner of your driver's license. The issue with that too, and it's not just for flying, it's actually, if you look into it, it's you're supposed to not be allowed in federal facilities right now if you don't have that on your ID. I keep pounding my wife about this. She's an immigration attorney. She's in federal facilities every day. She doesn't have the gold star in her ID. But it's a good point, because it definitely can be a tool that could be used to identify the location of these individuals, and also use that data to be useful towards the census in the future. I don't know how those 2 systems interact, which I highly doubt that they would, unless there's census workers somehow involved in that.
It's called homework for you people.
And but it's definitely a point that's well received. That it's something that could very much very well be used.
And because you were asking or suggesting that every single person who has contact with service workers who are servicing homeless populations, that they should be saying, are you registered to vote? Can I help you get registered to vote? This may be now the case this requirement to have these government issued IDs that are modifiers with a red gold star to otherwise push for that voter registration piece.
And I think that there's
the last thing I want to say is that I don't know why in the U.S. today, this is now 2020, it's so hard. The National Bar Association was an NGO that participated in South Africa's first free and fair elections when Mandela got elected. As you know, Mandela was a convicted felon, and he got elected to that presidency. The first day of voting in South Africa, and I was part of that process in the Transitional, the first day voting in the Transitional, we had to go to places where people were sick and shut in, like in hospitals and like, and or in prisons, or jails or whatever. And all those people allowed to cast ballots. In many respects, it was more humane than what was inflicted on the people who were not incarcerated, because they had to walk and stand on lines in the heat to get disenfranchised. We had to change the rules, extended days of voting with the IEC in order to make it happen. But that's not the whole story. That's for a different panel. It seems to me if South Africa figured out way back in the 1990s that incarcerated people should be able to vote even in situ, why are we struggling on this piecemeal, state by state, jurisdiction by jurisdiction approach to trying to get people who serve their time or are serving their time to get them able to vote? South Africa figured this out already. Duh, move on.
Did you want to answer? I can talk a little bit about the jurisprudence behind the felon disfranchisement in America. James, do you want to talk about the homeless issue?
Okay, I just want to add one last thing. If you bring up a good point, maybe that the idea of having a requirement to ID could be used as a carrot to dangle over someone's head. And my response to that is yes, it could be. That I think that there's multiple approaches that are going to work for different people. I have plenty of clients that I see that telling them voting is safe, easy, and fun would work, because that's a great slogan. You know, it helps demystify the process, especially when you're hearing you know, how crazy it is to register to vote, or how difficult it might be, or any this and that. And you know, it can seem like an overwhelming process, but you know, breaking down and saying, hey, here it is, it's digestible, can work. There's some people that you need to register for this, or you're not going to be allowed to live your life. You're going to be a second-class citizen. You know, some people need that tough love, if you will, or need that real talk. And some other people something else might work for another individual. But yes, I agree. It's a tool that we need to be able to use, or that we should be aware of its utility when engaging people that are experiencing homelessness, and just really our general populations that we serve in public service, and having that conversation about voting.
Thank you. Yeah, and one of the issues that Chad and I are struggling with in the Florida rights restoration case really is the legal standard that should be applied to felon disfranchisement or re-enfranchisement laws, because we've got a 1974 Supreme Court decision called Richardson v. Ramirez, in which the court essentially said that given some of the language in Section 2 of the 14th Amendment, Congress has already given full authority to the states to decide their voter qualifications and to deny someone the right to vote simply based on a criminal conviction. So the fact, to some extent, that states are even allowing folks who have a criminal conviction to come back on the rolls is being described as, by a state like Florida, the grace of the state, instead of something that is the restoration of a fundamental right. And so instead of being able to apply the strictest standard under the Equal Protection Clause with strict scrutiny, we're stuck with the rational basis standard, which, as many of you know, means that almost anything goes in terms of state policy. So it's been very difficult. Maine and Vermont and Puerto Rico are the only places that allow people to vote from jail. But you're right, South Africa, Ghana is another country. A lot of other countries are allowing individuals, as they are incarcerated, setting up polling places in the jail, providing access to absentee ballots. But because of this idea of tough on crime, because of the racial disparities within the criminal justice system and how people have interpreted what that means in terms of election outcomes, is, I believe, one of the reasons why we're still dealing with this problem. But I don't know, Chad, any thoughts on that too?
I don't have anything to add to that.
Okay. Other questions? We have a few more minutes. Yes.
I live in Arlington, Texas, down by the border, and I recently they had this meeting. There was a gerrymandering group gerrymandering meetings that are going around, and they had that meeting in my town. And
I'm laughing because the state calls them redistricting meetings, but you're probably right. They're all
so I didn't know anything about that. It was not well advertised, and I just happened to get an email from Texas Civil Rights Project. Otherwise, I never would have known that it was happening. So I went to this meeting, and I don't work in this area at all or know anything about this. But there were 3 people there. They held the meeting in the only town, the smaller of the 3 towns, Brownsville, McAllen, and Harlingen. The smaller one, Harlingen, which is the whitest one, and it was they're having these meetings before the census is done, and so they're saying, like, give us your feedback on our plans, but we haven't made any plans yet. So all you can say is, please do it fairly. It just seemed, so I'm just wondering if that's supposed to happen. It seems so bizarre.
So, I guess a few things about that. First, for those in the room that aren't familiar with Texas' disordered history, every redistricting the state has done from 1970 to the present has been struck down by federal courts. So, and for a lot of that time period, Democrats were in control of the state. So it's a bipartisan failure on the Texas government part to get redistricting right. And as recently as 2018, the Supreme Court struck down the state House map for being racially discriminatory. So Texas doesn't, it's got a long way to go to prove itself as capable of this. One of the complaints that we hear often, and I appreciate you echoing it today, is that Texas goes about and acts as though it's accepting public input, but as you mentioned, it's being done months before we even have the census data. And until you have the data, that's where the rubber meets the road in redistricting. So there are 2 sort of like laundry lists. As lawyers, you all know this, almost all causes of action or things in the law, we like to make lists, right, or elements. And so in the gerrymandering context, racial gerrymandering context, and I'm using that term a little bit wrong here, but in the voting context, to determine whether or not a particular redistricting system has a discriminatory effect, we use these things called the Senate factors And there are things that have sort of been globbed on by Supreme Court opinions to the Voting Rights Act and say these factors are in place, there's something wrong with redistricting that. Then there's another body of law on intentionally discriminatory redistricting in a case called Arlington Heights. The Supreme Court laid out some factors. These factors between Senate factors and Arlington Heights aren't exactly the same, but they overlap quite a bit. And one of the things that's always relevant is the extent to which the government took public input and was responsive to government public input, either in the redistricting under this type of case, and in other ways it could be responsive to various portions of its community. And Texas loses on that every cycle. So I don't understand why it is that I think the state ought to be lauded for going and getting some public input early and often. There's nothing wrong with that. But when the census figures come in, there needs to be some meaningful input from the public. And what Texas often does, and I'm afraid they'll do again, is they draw maps in the proverbial smoke-filled room. They're not shown to the public. If there is any public hearing, it's on just general concepts like, hey, would you do a fair job, or would you do it right? And then all of a sudden the map shows up on the House or Senate floor and it's adopted without any sort of public input. So obviously we're going to push again this time, as we have decades past, to try to get the state to do it right. Texas Civil Rights Project is obviously trying to do that, as LULAC and MALDEF and so many other groups. But it's a definite problem, and where these meetings take place are important. A lot of Texas doesn't have public transportation system, and whatever it is about Texas, we don't like rail systems, I don't know, but those elections lose much more than they win. Most of the communities here don't have robust subways or rail systems, and so people can't get to these meetings often. They're put in places like Harlingen, or they're put in sort of the suburban areas, and that's an issue as well. But these are all factors under those two tests I mentioned to determine whether or not redistricting's been done racially fairly. And there'll be factors again, there's no doubt this cycle.
Well, I testified on the record about it, so that's helpful to you later on.
Okay, it is. So we watch all of these, and of course, the public testimony, it's not fun, as you know, right? So a lot of times you gotta go down there, you sit for hours, it's disorganized. But the time that you took to do that is very important, and it will matter in the ultimate litigation if it's necessary.
Yes. So I'm from Selma, Alabama, and after all that, we still have so many issues around voting as early as our last election. Every most successful movements in this country, the battlegrounds were in the court, in the legislative body, and in the streets. And so I think sometimes people don't even realize how important voting is, but also the barriers that continue to exist. And so my question is around those three things. Are there some coordinated efforts that you all are connected with, having a three-part strategy in the courts and legislative bodies and in the streets?
Yeah, absolutely. I can say for SPLC, and then I'll ask others to join. We actually just on Monday issued a report called Alive and Well related to voter suppression in Alabama. And we talked about the polling place closures, we talked about the Secretary of State's fudging of numbers, in particular his use of voter purges. And then, so basically what he did is that he purged thousands of voters from the voter rolls, and then added them to the rolls, and then pretended like his voter registration numbers had increased exponentially because of the numbers of people that he had added to the rolls. And then in response to our report, he says that everybody doesn't know how to do simple math. And even though we keep pushing out the facts, we are dealing with this what is alternative facts. So, somehow that we're making stuff up, even though we can prove everything that we say in our report. So you're absolutely right. We're trying to do as much public education as possible. We're pushing on the legislative front for early voting. There is no early voting in Alabama, and they don't allow no excuse absentee voting. And then the Secretary of State's office response is, well, absentee voting is early voting. So now he's trying to converge these two very separate concepts to act like there's not really a problem. but we're trying to push on the legislative front. And then, of course, the litigation, which is inevitable, which is very difficult. You know, we just got a decision out of the Middle District in Alabama related to the fact that it has been almost impossible to elect black judges in some of the state court systems. And when we try to push for single-member districts so that communities have an opportunity to elect candidates of their choice, the courts are pushing back on that. So it goes back to what Chad was saying, is that the demographics on the bench are not even upholding basic constitutional principles or statutory laws that have been on the books for decades and which have actually helped to diversify government at various levels, including on the bench. So yes, we are engaged in an integrated advocacy strategy. We realize that we're going to need to rely on that more than ever because the courts, even though I do believe we need to keep these issues alive, are not going to be where the victory is won. It probably will be translating litigation losses into momentum for real people power movement. I don't know, what are your thoughts?
I think, so the question, as I understand it, is what are these organizations doing to coordinate? And they're doing a lot, but if I'm being fair about it, Shelby County versus Holder, the Supreme Court case that came out in 2013 that undermined part of the Voting Rights Act, was a bomb. And I don't think that yet the civil rights community, the bar, the academic community has yet completely come to terms with what that means. And Justice Ginsburg said in her dissent, you know, it's just like throwing out your umbrella when it's raining. And there's no question about that. And now there's got to be millions of smaller umbrellas put together by individuals in the community to fill in where the federal government's big umbrella used to play a role. And I think that, you know, there are roundtables that we participate in. Our organizations talk with one another and try to prioritize, you know, where they're focused. But I think one of the biggest issues, I don't want to repeat everything I said earlier, but getting information from your community is the piece that we've yet quite figured out how we're going to handle. But you know, there's various hotlines in every organization you can call, and as I suggested, you should do that. They're all fabulous calling you. But how we get this information, how we put it in a clearinghouse, how we broadcast it. Some places, as I mentioned earlier, can just be shamed into doing the right thing. They just need the attention brought to them, and they'll fix it. Other places, you're going to pry it out of their cold dead hand, so to speak. It's going to take a lawsuit. So are things like that happening? Yes, but we're about 4 or 5 years, I guess, from this disaster called Shelby County versus Holder, where basically the Old South and a lot of other places that had a substantial history of vote discrimination were essentially told you can go right back to it. And we were told they wouldn't go right back to it. For those of us who were sitting in the chamber when the decision was handed down and could see the tears on John Lewis and so many other American heroes' faces when John Roberts read the summary of that opinion, we knew immediately it would start raining, and it has. But we're not all in out of the rain yet. We're going to have to keep working at it, but it's a great question, and it's one we ought to wake up every day and ask ourselves.
Yeah, and we're also trying to push back on the divide and conquer. And one example has to do with the polling place closures. A lot of states are arguing, well, we can't use this particular polling place because it's not ADA accessible. And so that is an effort to pit voting rights activists against the disability rights community. And instead we're talking together, and the disability community is having our back by saying, we're not saying that you should close a polling place because it's inaccessible, we're saying make it accessible. And so that is an example of how we are not allowing the outsiders to divide our still relatively small power communities in terms of pushing, advancing progressive policies for all of us.
And that made me think of one other thing to add. This happens in the redistricting context. Oftentimes, they'll draw maps in a way that's designed to try to pit the NAACP against LULAC or MALDEF, and put the lines in a place to where it puts them in a position of potentially making legal arguments that are in opposite to one another. And there's I have to say, a yeoman's effort to avoid those kind of fights, and those organizations, I think, do a great job of avoiding this sort of divide and conquer. But there's no question that's a strategy.
Maybe time for one more question? Or not. We only have 2 more minutes. Thank you so much for engaging in this discussion. And again, I would encourage you, as James and Chad have advised, find ways in your local community to get involved. There's no excuse. Whatever your skill is, whatever your interest is, there is a role for you to play in making sure not only the 2020 election, but future elections are fair and free, and that the results really represent the will of the people. So thank you again so much for participating.